Good morning, good morning, good morning again, folks. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels, and we're going back to that horrible world known as the JRC. But before we do, the usual disclaimers. If you are new to either Stop the Shock or the campaign against the troubled teen industry, please go up into the description box. You're going to find all the pertinent links there. The one I find most worthy of note is going to be the article that is written by NeuroClastic, where they interviewed and surveyed over 900 ABA professionals in regards to the JRC's so-called behavior modification program. The JRC felt this particular article was so threatening that they have threatened NeuroClastic with a defamation lawsuit. They did not remove it from the website. So NeuroClastic refused. Please read that article. We also have the link to their public statement in regards to this particular threat, as well as their GoFundMe. We have the other links as well in regards to the Agape situation out of Stockton, Missouri. Folks, when we discuss places like the JRC and like Agape, you're going to hear vivid descriptions of and catch clips of surveillance footage of people with disabilities and mental health issues being tortured and abused. If you got young children present, please use the headphones. Trigger warning, this channel is marked not for kids for a reason. We use profanity on occasion and speak on dark subjects. So if your child is 16 and younger and they are watching these, very obviously, parental supervision is advised, all right? So where we left off last time, perhaps counterintuitively, given the intent of these statutes, the Youngberg-style deferential analysis carries over into the interpretations of the Rehabilitation Act, and by extension, the ADA. The courts have attempted to balance the rights of persons with disabilities against the responsibilities involved in running an educational program by holding that only actions in bad faith or out of gross misjudgment can constitute a Rehabilitation Act violation. So, what that would look like is, if you remember that interview with the four moms, right? When they used those intimidation tactics, and when that didn't work, they threatened to remove their guardianship only their own kids. That can be construed as actions in bad faith or gross misjudgment. Okay, that's what they're talking about here. That is an argument that can be made in regards to the so-called consent forms, right? What this means in effect is essentially the same as what it means for claims under the Constitution of the IDEA, that aversives will almost always be permissible under the law so far as the education and treatment professionals involved in their development and implementation approve of their use for a recognized purpose such as safety or treatment. This is why that is one of the main ones that we use to argue against places like the JRC. Because if a parent in a situation like that of the four moms can actually go ahead and prove the use of intimidation, the acts of bad faith, and not fully informing the parents of exactly the types of aversives that the kids are going to use, yeah. But with that, again, you see in this language here where it is once again deferring to the professionals, which is a massive problem because we are living once again in fantasy land. This idea that if the professional judgment declares that it is for their own safety or for the success of their treatment, you can hide underneath that type of language a whole slew of atrocities. All right? This is why, once again, we're pushing the bills and amendments that we are pushing, because the language is not specific enough, and because the courts have this horrific tendency to always refer to the professionals. Problem with that is not all professionals are created equal, nor do they always have the kids' best interests at heart. Okay? Let's move on. For example, the Eighth Circuit Court of Appeals in Heidman versus Rother not only held that the professional judgment rendered the use of restraint blanket constitutional, but also that it defeated liability for the purposes of the Rehabilitation Act, and that it would serve to undermine an assertion of either bad faith or gross misjudgment. You see where the problem is here, folks? It is this weird idea we have out here in America in our heads that the professionals know best, right? The truth is that is just simply not the case. Would we live in a world where I have had to go and get new doctors and had to explain to them in detail my situation? Yeah, not all professionals are created equal. But we don't live in that kind of world, folks. We live in fantasy land where the professional always knows best, no matter how horrific it looks in reality. Okay? Again, that's why we have to get more specific in our language, because this is one of those holes that I'm talking about that you can drive a diesel through. In taking such a hands-off approach, the Eighth Circuit and other courts have relinquished a considerable amount of their own power to enforce the protections of these laws to some of the very people who may at some point need to be enforced against. Exactly. The problem with some of these laws is there's this weird belief, almost a quasi-religious belief, that the professionals always know best. That if it is a doctor up there saying, no, this is what this child needs, they need to be shocked at just below the lethal limit. They need to be starved. They need to be sleep deprived because their behaviors are so out of control that this is the only thing that works. Unfortunately, we live in a world where people, because they have letters behind their name, no matter how insane it sounds, they're going to go with it. Nobody questions it. Well, except us. Okay? And why do they do this, folks? Money, 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 money. Okay? Point blank dollar signs. You have professionals backed by corps, by non-for-profits, okay? Who have access to unlimited funds. You see what we're up against now? And when you have laws that are not specific enough and that do not address aversives directly, see where I'm going here? That's why we're trying to get these bills passed that he's mentioning throughout this entire article that we're going over here. Because you got to have specific language, specific protections in place for these courts to act, because otherwise they are going to continue to rely heavily on the school district words and the so-called professionals' professional opinion. All right? These courts, much like the special ed departments, do not have the time or the funds to properly educate those who are going to be giving judgment on these types of cases in regards to the other treatment programs that are out there. Okay? Yeah. So if we want these judges, these courts, and these juries to start being able to protect these kids in a manner that is actually meaningful, The language has to get more specific. It has to address adversives directly. And not only does it have to speak on adversives directly, it has to be hammered home with extremely specific language. The guidelines, the regulations, the checks and balances in regard to use of said adversives. All right, let's move on, shall we? However, in 2009, a coalition of disability advocates and organizations filed a complaint with the United States Department of Justice, among other federal agencies, alleging that the use of the contingent electric shock and other adversives at a particular private facility, the aforementioned JRC, amounted to a violation of the civil and human rights of the people with disabilities. As a result of this, the Department of Justice agreed to open an investigation under the Title III of ADA, which prohibits private entities, including private schools and programs, from discriminating on the basis of disability when it came to goods, services, facilities, and accommodations. In particular, we use this law to target two things that this law actually addresses, such as when they starve and sleep deprive the students. Okay? We had to make use of the laws that we had and basically create an argument based off of them. All right? This investigation, which is still ongoing, unfortunately not anymore. Thank you, DC Circuit Court, you corrupt bastards. Could lead to a litigation that, if the government and the beliefs of the advocates prevailed, would result in prohibition of at least this particular facility's use of adversives. Such action by the federal government itself may also provide grounds for holding other educational programs accountable for their misuse of adversives, and as part of that, by shifting the way in which the law currently addresses this and related issues. So, here we all are in 2023. We got the ban to go through the FDA in 2020. And then 2021, that decision by the FDA was overturned by the DC Circuit Court, who asserted that the FDA did not have the authority to ban the device, in spite of the fact that is literally why the FDA was created, to act as a licensing, a check and balances to the different medical devices out there being used in treatment. The reason why we're pushing the two laws that we have spoke about here, the amendments, is as you can see, everything else has failed at this point. Every time we've had a victory, we end up taking 10 steps back, because we are dealing with an entity that has access to unlimited funds, that has an enormous amount of power. One small school has managed to essentially stop any and all inquiries into just exactly what the hell they're doing there. What makes it so bizarre is you will not see this anywhere else. We're not a whole industry like with the double teen industry where they all scratch each other's backs. This is one school, folks. One school that holds all this power and has continued on in spite of the fact that they have 6 kids literally dead at their hands. Okay? We have to combat it through law because there's no other way around it. But the laws on the books are not good enough, or we would not still be having this conversation in 2023. The language has to be changed. There must be federal guidelines, rules, checks, and balances on the books in regards to using adversives. Not just for places like the JRC, but also for things like the troubled teen industry. Because until that happens, we are just going to continue to chase our tails and chase our tails and chase our tails. And the only way we are going to get that specific language in to address adversives directly and get those federal guidelines and checks and balances in place, we have to have the help of the outside world. I'm a nihilist, folks. I've never been an idealist. It's been nothing but us advocates that have been hammering on this in regards to adversives for decades. And the reason why nothing has really changed, and the few times that it does, it always gets walked back, is because there is no pressure on these entities from the outside world. None. None. Okay? There were more eyes on JD versus AH, and if we want to go further back in time, the OJ trial, than there has ever been on this. That is what I am working here day after day after day on this channel to try and change. Yes, it may be a small audience. Yes, I may literally bleed subscribers because I am hammering again and again and again on the same topic. But once again, this is where my belief in the small kicks in. Because individuals who have subscribed and comment regularly on this channel have told others. And they have told others. And very slowly there has been a trickle from the outside world to start getting the word out about places like the JRC, places like Agape. But it isn't enough. And most of us have lost any hope that any real change is going to happen within our lifetime. But we're going to continue to fight because it's a fight worthy of fighting. But the outside world has got to get involved. Because as long as these politicians feel no pressure from the outside world to really do anything in regards to laws like this, we're going to continue to stand here like this. While kids with disabilities and mental health issues are being murdered and tortured every day while we're talking. So don't just watch this channel. You don't even have to use my channel as a link, for the love of God. List Autistic Hoya's YouTube channel. We have one of her videos linked on here. Link Jennifer Masumba's videos. Link the Shrouded Hand. Whatever links you use, it does not have to be this channel. Reach out, folks. This has always been, at its heart, a grassroots movement. So we have to act like a grassroots movement. Reach out. And don't just tell them about the situation. Bring them to articles like this, where we talk about the laws that we are trying to get on the books. We're going to close out on that. We don't get very many views on this channel. The few that we do get do tend to get removed from time to time. So please don't forget to hit the like button, hit subscribe, And don't forget to hit the comments. I do appreciate your time this morning. And as always, folks, we here at Spilling Tea hope you have a good one. I will see you next vid.